It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning, and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law, and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will hear what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law and areas related to them, such as protecting money from nursing home stays, securing benefits from programs like Medicaid and the VA, geriatric care coordination, estate and trust administration, guardianships, and planning for those with special needs. Nugen Law sees clients in many stages of life, but commonly we have folks reaching out when they or a loved one are showing signs of needing help. Those signs may include a chronic ailment or progressive decline before, during, or after a hospitalization, an instance of incapacity, caregiver burnout, stress on family members due to some or all of those instances I mentioned. So as a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. We take a life care planning approach to client representation, meaning that not only do our attorneys prepare any legal instruments appropriate for your unique situation, without additional cost, our clients also have access to our affiliated CPA firm, Certified Public Accountant firm, for preparation of their tax return, are invited to our client-only educational opportunities, have access to our Medicare specialist who advises on what Medicare plan and supplemental plan to secure, the ability to have your legal documents revised as necessary, and when appropriate, unlimited access to our elder care coordinator. Our ECC is a person who assists with whatever help our clients may need as they age. It could be any number of things that they perform for our clients, setting tours of various facilities, arranging for help in client homes, arranging moving and downsizing, and advocating for Nugen Law clients when necessary. If you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting for either our Fort Wayne or Auburn locations. You are also encouraged to see us online at www.nugenlaw, that's NUGENLAW.com. Today, I have a member of the Nugen Law interdisciplinary team, attorney Jesslyn C. Smith, here in the studio with me. Jesslyn is licensed to practice in Indiana, has been doing so in excess of a decade, and is the most recent past president of Indiana's chapter of the National Academy of Elder Law Attorneys. She was just a couple of weeks ago speaking at an event for attorneys statewide. So welcome, Jesslyn. Great having you on.
Thank you, Bryan. I'm excited to be here.
Good. I'm excited to have you on as well. Let's get into it. So here we are, the basics. What is an estate planning attorney? What is an elder law attorney? How do they relate? How do they differ? What's the difference?
Yeah, an estate planning attorney is an attorney that can prepare powers of attorney, healthcare representatives, wills, and trusts. But I think the difference or the distinction then between an elder law attorney and an estate planning attorney is an elder law attorney takes a deeper dive into a client's situation and kind of thinks ahead in a way. And what I mean by that is we look for, are there reasons that we need to create things such as supplemental needs trusts within the estate planning documents? Are there certain trusts we need to use to protect assets in their situation because of a cognitive disability or a physical disability that they may have? So we kind of look at a bigger picture than just standard traditional estate planning attorneys that prepare basic documents.
Sure. I like to say that elder law attorneys do everything estate planning attorneys do and much more. And I do think that there is a place for both practices, but truly, as you're aging, you would be well served to make sure that you're speaking with an elder law attorney. It's not what you know. Sometimes it's what you don't know. Mm-hmm. And I have had instances, and I'm sure you have as well, where someone has come to us as a client and, they spoke to an attorney and they told them to do A, B, or C, and, makes the hair on the back of our neck stand up. Uh-oh, we've got a problem. Mm-hmm. Or they thought they were protected as they age, and really they aren't. They aren't protected. Yeah,
actually, a prime example, yesterday met with a client. Yeah. Nursing home was assisting with filing for Medicaid. And again, you don't know what you don't know. And he kept saying, well, I didn't know this. And I said to him, you don't know what you don't know. Right. And that's why you're here now. No. I'm like, that's why you're here now, so that we can guide you right down the right path.
For sure. So I do think that that's important when you're speaking with someone counsel, that they are really an elder law attorney, and not just saying they're an elder law attorney, to really understand what it is for special needs trust to work. When I think of estate planning, I think of when you die, I've prepared documents for you that will address how those assets are distributed. When I think of elder law, not only are we doing that, but we're working with you during your lifetime. We're protecting your money during your lifetime. We're securing benefits during your lifetime. We're providing those other resources I was mentioning earlier, that elder care coordinator. In our office, we, as I say, we have the CPA firm involved, and a Medicare specialist. We're really taking a much more holistic approach to caring for our clients.
And I think our clients appreciate that, Bryan, because you really don't realize how one little thing can maybe affect that other situation. Sometimes when we're putting in these asset protection plans for clients, how that may affect what you may need to file with your taxes, such as gift tax returns. So it's nice that we have in-house the resources that the clients need in one spot.
Yeah, for sure. So, Jesslyn, you categorize yourself as an elder law attorney. I categorize myself as an elder law attorney. We call ourselves an elder care law firm, so that to me is something that really sets us apart. Jesslyn, before your first meeting with new clients, are there things you encourage them to think about before they hit the door?
Yes. We like to encourage clients to start thinking about where and who it is they want their things to go before they come in, so that they kind of have an idea with regard to that. And also thinking about what their goals are. Someone's goals may be very different than someone else, depending on their family situation. Somebody may have the goal, I have a disabled child, and I want to make sure that child is specifically taken care of. So if that's what's important, we want to talk about what those options are with the client. Or they may come in and say, what's most important to me is to avoid probate.
And who is it that's going to do those things for you?
Yes.
Yeah. Who are the players going to be for you?
Right. The who, what, and when.
Yeah, for sure. What information or documents should your client bring to their initial meeting with you at Nugen Law, Jesslyn?
Well, we like to have them fill out an intake form for us to give us their basic information about themselves and their family. And then we also go through and ask about some basic information on their assets. I don't need exact numbers and things like that usually. Right. I just need a rough idea so that we kind of know what to discuss within that situation. Previously clients were worried about inheritance taxes or taxes after death,
Right.
And what happens with that. Usually it's not going to apply to the clients, but having that basic knowledge of what they have lets us know that we can tell them that.
A couple of points. I think that when you're talking about taxes, normally not an issue. People don't realize that there is no Indiana inheritance tax. And the federal estate tax this year is $13.61 million. So I can pass with nearly $14 million in my name before someone has to pay federal, or before the estate pays federal estate tax. It affects a small portion of our population. Does it happen? Yes.
Right.
But it is not most folks.
Correct.
So I think one of the things we can do immediately is ease people's minds that, nope, at the time of your passing, I wouldn't be too concerned about your having to pay federal estate tax. I also think it's sometimes when clients are just getting to know us, they're kind of holding their cards close to their chest. And you mentioned about, I don't need to know the exact dollar amounts. I mean, eventually we want to talk about those things.
Yeah.
Because it helps us understand what we're working with, what we want to get accomplished. But oftentimes what's more important to us is, how is it invested? Is it in cash? Is it in a brokerage account? Is it in a money market? Is it in a CD? Do we have annuities? Do we have life insurance policies? Do we have qualified money? When I say qualified money, I mean IRAs, 401ks, 403bs. So those types of vessels that are holding your money become very important.
Correct, because with those vessels, each one has different ways that may already have some of your goals accomplished, although they may not be appropriate for your situation too, as we take a deeper dive into your situation. And what I mean by that is some of those vessels may have beneficiary designations on them. Mm-hmm. But with beneficiary designations, I caution clients that doesn't leave somebody in charge to make decisions. And if everything is passed through beneficiary designation, there's no requirement to make sure bills and things like that are paid and taken care of at your death.
There are times when a beneficiary designation is appropriate.
Yeah.
But I don't think people recognize that if I put on an asset, for example, I have a brokerage account and I say this goes to my child. So what they don't take into consideration is if something happens with that child between now and your passing, where they have a car accident or they have had an illness, and they're inheriting that, receiving that from that beneficiary designation, nothing was done to protect it, so that we didn't require that to be spent on their care. But if we're doing proper planning, they still can have the benefits from all of that money. We can drop it into a special needs trust. What was your phrase?
Supplemental care trust.
I'm going to use that, supplemental care trust. I think that tells the person more. Technically, special needs trust.
Yes.
But supplemental care trust tells the person really what it's doing. It's supplementing the care of the individual. So the money doesn't go anywhere, but it's protected for them. If we use a beneficiary designation, we say it goes to my child. If my child passes away, it goes to their children. Of course, the concern with that is if the grandchild is a minor, then the in-law is going to be managing the money until they hit 18. Then at 18, the grandchild gets all the money.
Right.
I would like to say that I was as fiscally conservative with spending my money then at 18 as I am at my age, but not. I wasn't. And I don't think most people are.
Right.
So with your planning, we can say money goes out at 23, 27, 35. You can set it up. So beneficiary designations can be a good thing, but they need to be used judiciously. What are you normally focusing on, Jesslyn, when you're meeting your new clients at Nugen Law? And what goals do you want to achieve for your clients in those meetings?
Yeah, the very first thing I ask the clients is, tell me a little bit about yourself and what your goals are,
right,
and what you want to know from this meeting. And so they start to tell me about themselves and then tell me what it is their goal is. And then that helps me decide where the conversation's going to go and how I'm going to educate them. My goal is to educate them on their different options and then let them choose what they feel is the best fit for their situation.
Right. I feel the same. My job is to educate. I don't make decisions for my clients. I don't tell them what to do. I want them to have a positive experience. People, when I'm going to the lawyer's office, they get nervous. They think, I'm going to say something that isn't that sharp, or I don't have enough money to see a lawyer, or I don't have enough, situations going on in my life right now to see somebody that's an elder law attorney. All of that should be set aside. There is not someone that has too much money or not enough money. Everybody needs to have that planning in place, for sure.
Correct.
So as a reminder, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. Nugen Law takes a life care planning approach to client representation, meaning that not only do our attorneys prepare any legal instruments appropriate for your unique situation, and without additional cost, our clients have access to our affiliated CPA firm for preparation of their tax return, are invited to our client-only educational opportunities, have access to our Medicare specialist who advises on what Medicare plan and supplemental plan to secure, the ability to have your legal documents revised as necessary and when appropriate, and very importantly, unlimited access when appropriate to our Elder Care Coordinator. So that Elder Care Coordinator, or ECC, is a person who assists with whatever help our clients may need as they age, figuring out what does their Medicare pay for, what does Medicaid pay for, what does VA pay for, what don't those programs pay for. I want to schedule a tour to see various facilities, nursing homes, hear which facilities have you had good experiences with, maybe what facilities haven't you had good experiences with. Is this the right place? We could arrange for folks to downsize when they're leaving their home and moving to different housing arrangements, and advocating for clients when necessary. So if you're getting care in the home and you're not satisfied, our Elder Care Coordinator can reach out to the agency or the individual providing the care and can address and remediate the issues. Or there's a concern about care that's being provided in a nursing home or a memory care unit, that they would be able to advocate on behalf of our clients. So if you hear something in today's broadcast which resonates with you, an area in which we may be able to help, please call Nugen Law at 260-925-3738, speak with one of our intake specialists, and schedule a meeting for either our Fort Wayne or our Auburn locations. You are also encouraged to see us online at www.nugenlaw, that's NUGENLAW.com. So there are lots of different types of instruments we discuss and prepare for our Nugen Law clients. Jesslyn, let's educate our listeners about a couple of those. First, the instrument most people think of when they think about estate planning, last will and testament. Jesslyn, what's a last will and testament, and what's the purpose of a will?
So a last will and testament is an instrument where you designate who you want to receive your estate when you pass away and who's in charge of making sure those wishes are carried out. Mm-hmm. And essentially the will then means that your assets will go through probate.
What is probate?
So probate is essentially filing with the court and having the court appoint the person you named in the last will and testament as your personal representative, and they oversee and make sure that the assets are distributed according to that will.
So I oftentimes have people during our first meeting just say, as I'm sitting down and greeting them, all I need is a simple will. Simple will. That may be the case, or they may need something else, but I encourage them to allow me to speak with them, get to know them, and learn about their goals, and then allow me to make some recommendations for them to consider. Our client is always in charge. They make the final decision, but I want to make sure it's the best informed decision for them to achieve their goals. I want and enjoy, and I know, Jesslyn, you feel the same, for them to use our training, our education, our experience to reach their goals. How long, you mentioned before, for using a will, when we go through probate or estate administration, how long does that typically take?
So it can take anywhere from 6 months to a couple of years. Usually it's about a year, but there is a wide range of how long it can take.
And that process is called probate, or going
Correct.
through the probate process. So when you hear people saying to avoid probate, it's that estate administration process that takes 6 months, 12 months, 24 months, etc.
Correct.
And is there a cost associated with going through probate?
Absolutely. There's court fees, and then there's also fees for the administration of that by compensating the personal representative, and also attorney fees and funeral arrangements and things like that.
People are sometimes interested to know that a will is also public record. So once you pass and we spread that will of record, if I'm a nosy neighbor, I have the option of taking a look at that will and see, what did Bryan do? Who did he remember? What did Jesslyn do with her money? Who did she remember? Oh my gosh. So that's public. And sometimes people are not interested in having their affairs made public.
Especially if they're doing some kind of different distribution. They may not want everyone in the family or a neighbor to know that I left only X amount of dollars to one and the rest of it to another.
Yeah.
So, a lot of people really value their privacy and not having their wishes out in the public.
So all that being said, we do represent clients through the probate process. We have dozens of estates open right now in our office that we are actively going through the probate process. But let's not forget, though, about one of my favorite estate planning tools, and that's the trust. So when I mention use of trusts to clients, they become a little nervous. This is what I see on their face, so their arms are crossing because it's something they're not familiar with. They're concerned if their estate is large enough to merit having one. How do they manage a trust? Is it going to be expensive? The term trust covers a very large umbrella of instruments. Jesslyn, let's start. What is a trust?
A trust is simply a contract that you create to hold your assets and make the determination of where you want your assets to go when you pass. And who's in charge of doing that.
Sure. I describe it as a beneficiary designation on steroids, meaning that trust is a giant beneficiary designation. Mm-hmm. So just like on your IRA or your 401k at work, you say, if I pass, it goes to my wife, or if my wife has passed, it goes to my children. A trust can do that, but it also can say the money is going to go to my children. However, I don't want them to receive their first distribution until they're 23. And I'm not going to give them everything at 23. I'm going to give them 20% at 23. I'm going to give them another distribution at 27, 28, 29. I'm going to give them their final distribution at a later age. Or if you've seen your children are mature and handle money, get it to them all at once. We can include language in those trusts that if somebody is unwell, they have an illness, they have maybe they suffered a brain injury, something like that they're still getting that money, but it's protected. And because it's a beneficiary designation, Jesslyn, do we have to go through the probate process when we're using trusts?
No. Trusts are private. They are not public. You don't file them with the court. The trustee has immediate access to the assets in the trust, because once that successor trustee is in place after you pass, they're the key holder. So they don't have to wait to get something filed and be appointed by the court, or wait 45 days under like our small estate statute. So
So I describe to people, if the minute you pass, your successor trustee, whoever you've named, could be a child, doesn't have to be, they immediately are empowered to do exactly what that contract says. And if that contract says everything's distributed to my children, 1, 2, and 3, truly, the trustee at that time could say, I'm going to write check 1, check 2, check 3, and we're done. Mm-hmm. No court, no attorney, no ongoing costs. That simple.
Yeah.
Real estate. You could get the real estate listed for sale immediately. You don't need to wait for an estate to be opened. You don't need to wait for letters to go out to all the individuals that may be beneficiaries of that estate. We can immediately process those things.
Correct.
So the players of a trust. When I talk about a trust, I think of the trust maker, the settlor, the person that did it. I think of the manager, the trustee of the trust, then a beneficiary. Can you go through each of those three categories and explain what those are?
Yeah.
And typically, if we're talking about strictly estate planning, revocable trusts, who are typically serving in those three capacities?
The trust maker is the client, the person creating the contract and making the decisions of where everything's going to go. The trust maker then also usually serves as the trustee in the revocable trust because they're going to have that. The trust maker, too, if it's revocable, has the right to amend or change the trust during their lifetime.
Right.
And then they serve as the trustee, which means they're the manager of those assets that are in there or the key holder and have the access to the assets if they need to use those. And then on the beneficiaries, there's two types of beneficiaries, the lifetime beneficiary and the ultimate beneficiary. And that trust maker is also usually going to serve as our lifetime beneficiary. They still have the right to receive the benefit of those assets while they're alive. And then after they've passed, the ultimate beneficiary then is who they've named to receive those assets after they've died.
Mm-hmm. Or if during their lifetime, right, they become incompetent or incapacitated, that trust also permits someone automatically to step in and manage the money and distribute the money generally for the benefit of the client.
Correct.
It's not that trustee, if it's someone other than the client, can all of a sudden start taking money for themselves. Typically, the trusts are written so that the trust maker, the settlor, is the one that can benefit from it, regardless of their competency.
Correct.
Sure. Fair enough. Is there a magic number that somebody should have, number of zeros behind their investments before they consider doing a trust? Right? People will ask me, clients will say to me, do I have enough for this? Is that the decision maker on whether or not they need a trust?
Absolutely not. Trusts are not just meant for what people think of as like the trust fund babies or things like that.
Yep.
Again, it's about what your goals are and what's important to you. You may just have real estate that's most important to you. And so no matter what the value of that is, putting that in there to help avoid probate and making sure that access is available right away after you pass may be the reason why you need the trust. It doesn't matter how much it is.
No. I do think another common question or comment I hear from people is, where does the money go? Right, it's in the trust. Where does the money go? Is there a trust department somewhere handling it? Is there, somebody that's in charge? Is Nugen Law in charge of this money now that I've created that trust? Is that what's happening here?
No. Your investments and everything that you have stays where it's at. We just change the ownership. So instead of it just being in your individual name, it'll say the title or the ownership is the name of the trust. So it all stays right where it's at.
Right.
We just change the ownership of it.
And even the taxation of the trust, so those revocable trusts, does a child pay tax on the money there? Does your tax go up because you're using a revocable trust? Does anything change as a result of that?
No, it doesn't. The rules don't change on that. So no inheritance tax for the kids when they inherit it. Unless you owned more than the $13.61 million, then there could be federal estate tax. But no, there's usually no inheritance tax.
Right. Fair enough. So as a reminder to our listeners, Nugen Law represents clients in Indiana, Ohio, Michigan, and Florida. Nugen Law takes a life care planning approach to client representation, meaning that not only do our clients prepare any legal instruments appropriate for your unique situation, Without additional cost, our clients have access to our affiliated CPA firm for preparation of their tax return. They're invited to our client-only educational opportunities, have access to our Medicare specialist who advises on what Medicare plan and supplemental plan to secure, the ability to have your legal documents revised as necessary. And I think, too, what really sets us apart at Nugen Law is we have someone called an Elder Care Coordinator, an ECC. This is a person that does everything for you that you need to age successfully, from advocating for you to finding a facility for you to move to if appropriate, downsizing, etc. So, Jesslyn, thank you for joining me and our listeners today. You've provided some invaluable insight. I look forward to hearing from our callers if they need some help at 260-925-3738. I also look forward to next weekend, Saturday at 9 a.m. for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. Enjoy your weekend.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to NugenLaw.com or email help@NugenLaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.
Podcasts by Federated Media.